Good afternoon and welcome. Thank you all for joining us for this presentation on family law, matters addressed in a dissolution of marriage or divorce with children. My name is Japonica Jackson. I am the staff attorney pro bono development at Community Legal Services. I'm just going to tell you a little bit about CLS. So at CLS, we believe in legal aid for all. Being the largest legal aid in Central Florida, our mission is to provide no-cost legal services to the most vulnerable in Central Florida and help them protect their families, health, and livelihood. We provide legal information and assistance in multiple areas of law to eligible individuals. Now, before I introduce our speaker, I just wanted to go over a few housekeeping items. Number one, during this presentation, Melissa will be providing legal information and not legal advice. At the end of the presentation, we will provide you with any information on how you go about getting legal advice. If you have questions during the presentation, if you'll just raise your hand and Melissa will address those as she's going through the presentation. However, we ask that you ask your questions in general terms as to not divulge any personal information. And lastly, this presentation is being recorded. Now on to our speaker. Melissa grew up in Lake County. She attended the local schools there. She is a UCF undergrad and attended FAMU College of Law for her law school. She has been practicing since 2005 and has worked as a prosecutor in both Lake and Citrus counties. She has been doing family law and criminal defense for about 7.5 years and has also done some dependency work. Melissa is employed with the law office of Melissa Militello, where they have more than 54 years of combined legal experience. At Melissa Militello, PA, they work to provide aggressive criminal defense representation to clients in the Inverness, Florida area. As former prosecutors, their attorneys have the knowledge and practical experience to offer the detailed and insightful defense counsel one would need to limit the penalties of a misdemeanor or felony conviction. In addition to criminal defense, they also represent those dealing with divorce and family law issues. Without further ado, please welcome Melissa Pendergrass.
Good afternoon, ladies and gentlemen. I think the first thing to acknowledge when we're talking about divorce with children is the impact that the divorce does have on children, and that it's important for parents to realize that the impact can be very severe depending on how contested the case is. Most all of our judges in the circuit, well, all of our judges in the circuit want no children involved in a divorce or family law case in any way, shape, or form. And in fact, there are some family law orders that go in place anytime a case is filed that particularly advises parents that the children should not be involved in any way, shape, or form. So anytime you're talking about a situation with children, even to the extent that they may be older children, it does affect children very deeply to see their parents in this type of situation. So it's very important to make sure that they are left out of this process as much as is possible. There are different types of processes people can go through when they're looking at a divorce situation. If the parties have a pretty good idea of what they're wanting to do and what they're willing to agree to, the divorce could ultimately be what's called an uncontested divorce. In that type of situation, the parties have gotten together and they have decided how to divide their property, what the time sharing arrangement's going to be, what the child support is going to be, and essentially they, if they're unrepresented, ultimately have a hearing in front of a magistrate or a judge, and the divorce is final, and the magistrate or the judge ultimately orders what they've agreed to. If there is a situation where the parties have not completely come to an agreement, but are really wanting to try to stay out of the court system, there is a process where they could go through an early mediation. And essentially what that process would be is they contact a private mediator or an attorney. There are attorneys out there that offer these specific services to try to come to an early agreement even prior to filing the court case. Another option would be collaborative divorce. A collaborative divorce is a specific process where people can, each party is represented by an attorney. There's also a financial person involved, and sometimes also like a therapist or a neutral party. Everybody meets together typically once a month to discuss the issues in the case and slowly but surely get to a resolution in the case. Again, the idea is to have the family work through the process together and come to an agreement prior to getting to a litigation type situation. The collaborative process can take place after a case is filed as well, and it kind of puts a pause on what's going on in the courtroom. The important things to know as far as the case itself is the process in general. First of all is the paperwork. There's a couple of different places that you can actually get the paperwork if you're representing yourself. If you're represented by counsel, then counsel would be doing the paperwork for you. But ultimately, there's a couple of different places. First of all, you can contact your local clerk's office. Generally, they have packets available that you purchase from them that has pretty much all the documents together. Another option is to go to floridacourts.org, and they have all of the documents that you will need to file your case. If you go to floridacourts.org, they're not listed in any particular, they're not listed according to what you'll need for your particular type of case. It's just a list of all of the various documents. So you need to read the instructions very carefully as to how to fill out that one particular document, as well as it gives you hints and points you into a direction of other documents that you will need to file. Once the paperwork is completed, it gets filed with the clerk's office. The clerk's office will issue a court number and a summons, and that summons is how you inform the other side that the court case has now started. So typically, a private process server is used. Sometimes, depending on the county, the county offers service of process through the sheriff's office. Once the person is served, they have 20 days to respond to the lawsuit. And they as well can go through either the clerk's office or through the floridacourts.org website and find the appropriate paperwork to file the response. Once they file that answer, which they have 20 days to do, discovery typically starts. And that's where you exchange financial information to include bank statements, pay stubs, financial affidavits, all of that information that will ultimately help in deciding how the marital assets and liabilities are separated, as well as determine what the child support will be. Once the discovery is done, typically the next step in the process will be mediation. There are two different options as far as mediation is concerned. One is going through courthouse mediation, and the other is going through a private mediator. Courthouse mediation is determined based on a person's income. Typically, the max cost per person is going to be $120, but that cost could be reduced, which is determined by the financial affidavit and how much each party makes. Private mediation, prices definitively vary as far as the mediator, how much experience they have, where they're located, how they appear, and In general, you're looking at probably about $100 per hour per person for a private mediation. At mediation, that is where the mediator, who is a neutral party, will assist the husband and wife in trying to litigate and determine what should happen in ultimately their case. If everybody comes to an agreement at mediation, then ultimately the mediator drafts up the agreement and it's sent to the judge for a final hearing or a final signature. If it's a partial agreement where you've agreed to some things but not all, it will then, the parts that were not agreed to will go to the judge or the magistrate, and then the mediator will write up the rest of it. If no agreement is made, then ultimately all the issues go to the judge or the magistrate. It should be noted that in many of the counties in our particular circuit, we do have what's called Unified Family Court, which is kind of a nice little thing. It's a situation where if you have multiple cases going on at one time, say a divorce and an injunction or a juvenile case, you can motion the court, sometimes the court will do it on their own, to move all the cases in front of one judge, so only one judge is making that determination. Some of the costs associated with a divorce situation is the filing fees that are paid to the clerk's office when the case is initiated. Those filing fees can be waived in certain circumstances, and there's a very specific form that you would have to ask to fill out in order to see if you would qualify for that. Otherwise, the filing fee is paid to the clerk's office. Sometimes service of process, there's a fee associated with that, as well as the cost of the mediation. Going specifically into some of the issues that parents have to address in a divorce with children, one of the big ones is time sharing. And it used to be, particularly when I was a kid, parents would talk about custody. And there was a primary and there was a secondary custody. And that's not how we look at things anymore. The state of Florida feels that it's in a child's best interest to have both of their parents in their lives. And as such, we have structured our laws to promote that situation. So we talk about time sharing. Time sharing can look like a lot of different things depending specifically on the situation. But that's how we talk about how parents' time will be, or how the children's time will be divided between the parents. The other thing that we talk about is parental responsibility, and that is who is going to make the decisions for the children. Ideally, again, the state of Florida and our judges would like both parents to be equally involved in doing what's called co-parenting, in making those decisions for the children. In a situation where parents are co-parents and they have equal responsibility regarding the decisions of the children, that's going to be called shared responsibility. In most circumstances, that's what ultimately is going to happen when it comes to a children and time sharing situation. And what I'm talking about when I'm talking about parental responsibility is those decisions like where the children are going to go to school, or what medical providers are going to be used, what medical services can be done. The ideal situation with shared responsibility is that the parents are communicating amongst themselves and making a determination together as far as what's in the child's best interest. In situations where either one parent is not available or it's not in the child's best interest for that parent to be making a decision, we have what's called sole responsibility. And that can be to all decisions regarding the children, or it can be to very specific areas, such as one parent has sole responsibility in making school decisions. The time sharing arrangements ultimately like I said, it can be a lot of variations. A lot of it depends on where the parents are living first and foremost. If they're living very close together, obviously a 50-50 time sharing is a more feasible thing to do. That can look like a whole variety of things as well, such as week on, week off. It can look like one parent has Monday, Tuesday, the other has Wednesday, Thursday, and they swap off on the weekends. A lot of it can be very specific to the family's schedule, work situation, and if parents are agreeing and making the decisions themselves rather than waiting for a magistrate or a judge to do so, they can be a little bit more creative in what that schedule ultimately looks like. When we're talking about time sharing and writing out what the schedule should be, we're talking about overnights. So where the child is during the day, it does matter, but when we're documenting it in paperwork, we're talking about where the child is going to be overnight. And that's important when it comes to the next topic, which is child support. Parents should know that child support in the state of Florida is something that cannot be waived by either parent. So even though parents have agreed that nobody's going to pay anything, it may not necessarily work when ultimately it goes in front of the judge or the magistrate. Because we find that the child support is the right of the child, not the parent, it has to be addressed in some way, shape, or form. And the way it's addressed is by looking at those financial affidavits, which are part of the paperwork that you initially file with the courts, which give what the people's income is and who pays for what, such as child care and health insurance for the children. Once the financial affidavits are obtained, the next thing that we look at is how many overnights each parent has for the children. And basically the calculation is done per Florida statute and comes up with what the amount is. If you're talking about a situation where parents are going to be doing, say, 50-50 time sharing, they have pretty much equal incomes, then those are situations where we can look at parents not having to necessarily pay child support. Again, it's something that absolutely has to be addressed, and the judge or the magistrate, when it comes to that final order, will take a look and make sure that it was taken care of in some way, shape, or form. But again, if parents are able to come to an agreement prior to getting in front of the judge, there are more flexible ways that we can address child support, particularly if it's a situation where the parents aren't living close together. So in that type of situation, we would be looking at more of a long distance parenting plan, and the time sharing kind of breaks down to the school schedule versus the vacation schedule. So one parent ultimately has the children essentially during the school break or the school time, and then the other parent gets majority of the time during the breaks. So that would be what a long distance time sharing schedule would look like. Obviously, if it's somewhere in between where it may be a greater distance between the parents, but not like 5 hours of travel, it may be more feasible to have a schedule where the parent who is living a little bit further away has, say, weekend time sharing in addition to what's going on during the breaks. Something that's important, particularly if people are representing themselves, is that you have to understand that even though you are representing yourself and you don't necessarily have a legal education, the judge and the magistrates hold you to the same rules that attorneys have to follow. So it's very important to know what the local rules are as well as what the local procedures are. One of the ways that you can find that information out, particularly in this circuit, is go to circuit5.org, where it lists who all the judges are, who the JAs are, the judicial assistants, as well as if that particular judge has any particular rules that they want followed as far as procedures or their courtroom. As far as representing oneself, it is possible to get through the divorce process, even with children, by representing yourself. One thing that I would caution people is to absolutely know what your rights and responsibilities are. Even if you can't necessarily afford an attorney for the entire process, many family law attorneys will sit down with you for a small fee to do a consultation. And during that consultation, you can ask the questions, you can get information on what your rights and responsibilities are, and at least have some sort of path forward. Another option is local legal aid. We have a wonderful organization in our community, and Japonica will come up and talk about that here in a few minutes. They can offer services. Sometimes it is complete representation, sometimes it's helping with the paperwork, sometimes it's helping, putting you in contact with attorneys who will talk with you. But even if that is not an option, I would strongly suggest at least consulting with an attorney. It may cost you $100, $200, but what you get in that hour of time may save you in time with your children particularly, or in child support in the long run. Don't rely on what happened to your neighbor or what happened with your best friend or even what your parents advise you your rights and responsibilities are. Things are constantly changing, and it's important also to know, the local judges and magistrates, because each one of them can do things a little bit differently and may have certain preferences. So talking to a local attorney who kind of knows the landscape is a very important thing, even if it is just for that simple consultation. Some attorneys out there are kind of changing the way they practice, and they're doing what's called unbundled legal work, meaning that they're willing to help you for certain parts of the case. So it may be help in preparing the paperwork. It may be going with you to mediation, or if absolutely necessary, that final hearing or trial, helping you prepare for that and helping you with that process. So there are a variety of options out there, but it's important to understand what your rights and responsibilities are.